I'm Kate Ling. I'm the Director of Content Strategy here at E&E News. We are joined today by Ellen Gilmer and Amanda Riley. We're going to talk about the environment and energy legal landscape, which is very interesting these days, especially since President Trump took office. So thanks for joining us, ladies. Mm-hmm. Let's start with the Supreme Court. It's coming back into the fall session next week, and there's some very interesting things going on, particularly the Clean Water Act. But what else might be happening, and walk us through what's going on there.
Sure. Well, on the Clean Water Act, the court will hear a challenge or arguments on October 11th related to the Obama administration's Clean Water Rule, or otherwise known as WOTUS. The case there is over which is the correct legal venue for challenges to be heard, whether it's federal appeals courts or federal district courts. And so there's some language in the Clean Water Act that kind of gives the appeals court jurisdiction over certain types of rules. And so the case is about whether the Clean Water Rule fits into that language.
Okay, so it's not actually on the rule itself.
Right, but it will be important for the Trump administration, which is trying to get rid of WOTUS and replace it with something else. Because this case will then determine where challenges to that rule, to the replacement rule, will end up. So big implications for the Trump administration, even though it's kind of on a wonkier legal subject.
Okay, and there's some cases then that might come up. We're not sure yet.
Right, yeah. So the justices on Monday will be meeting for their opening conference, which is how they kick off each session. And over the summer, as is usual, dozens and dozens of Supreme Court petitions have been filed, so they'll start deciding whether to grant those petitions and take up cases. So kind of, we don't really know yet what other environmental cases they may take up, but there's some interesting Clean Air Act cases out there. There's some Endangered Species Act cases. There is, one of those cases is kind of looks at the extent to which climate change should be taken into account in Endangered Species Act listing decisions. One other case that's getting a lot of interest in terms of amicus briefs filed is groundwater rights for Native tribes, whether tribes have a right to the groundwater that's below their reservation. So again, not sure whether the court will take up any of these cases, but be interesting to see how that goes.
And it'll also be interesting to see what Judge Gorsuch ends up doing in his first term.
So obviously he's still relatively new to the court. He hasn't written any opinions on environmental cases yet, so I think we're just kind of in the community, we're kind of waiting for the environmental community is kind of waiting for where he'll end up on some of these issues.
Right. And you noted climate change being potentially sort of on the docket for the Supreme Court, but that's something that a lot of the other courts have actually been dealing with in environmental reviews and such. And Ellen, can you sort of take us through some of what's been happening there?
Sure. It's been really busy in the lower courts on how agencies need to consider climate change when they do environmental reviews under the National Environmental Policy Act. One of the biggest cases we've had recently was from the D.C. Circuit, and it was last month the D.C. Circuit ruled that FERC, the Federal Energy Regulatory Commission, needs to think about all of the downstream greenhouse gas emissions from a natural gas pipeline it was permitting. And not just in a kind of quantitative broad way, or in a qualitative broad way, but in a quantitative, very specific way. The agency needs to be thinking about that. So that case was about a month ago. We don't know yet whether the decision will be challenged. It's certainly possible, but in any event, it has really big implications for other federal reviews of pipelines and beyond pipelines. And another case just Friday we had from the 10th Circuit, and it was similar. It dealt with the Interior Department's environmental review for coal leases in Wyoming's Powder River Basin, and in that case the 10th Circuit held that Interior needed to look at all these climate impacts more specifically than just this sort of broad brush approach it had taken.
Yeah, that's really interesting, and there was some other cases, I guess, in Montana that something happened similarly that was,
Right. So there was a case over the approval for a mine expansion, underground coal mine expansion in Montana, and there a federal district judge found that the Office of Surface Mining Reclamation and Enforcement
was a mouthful.
in that case they had sort of come up with a number for the greenhouse gas emissions that might come from that mine expansion. But what the judge found that the agency didn't do was then it didn't calculate the sort of the economic impacts or the put a dollar amount on those emissions. It faulted the agency for not doing that because it had put a dollar amount on the benefits from the mine expansion. So the court said you can't just look at the benefits of it without also taking into account the costs.
Yeah, that's really interesting. Is this something that we're going to consistently see then moving forward, do you think, in terms of how the courts deal with the environmental reviews? I mean, is this sort of setting precedent?
So it's definitely setting precedent, but how far that precedent goes, we'll have to wait and see because every case is different. It has different facts. It's before different judges who have different approaches to things. So we don't know. And for example, in the DC Circuit, the same court that handled that pipeline case where a panel of judges, 3 judges, decided that FERC needed to take a closer look. Actually, it's 2 judges and 1 dissent. So they decided that FERC needed to take a closer look at greenhouse gas emissions, but that a different panel in that same court a week earlier decided that the Department of Energy did not need to do that for LNG exports. The court deferred to the agency's determination that kind of quantifying all of those emissions was kind of skeptical, was too speculative and too, broad to be useful. So. And that was just a week before the pipeline case. So we could definitely see some inconsistencies in the courts just depending on the facts of each case and what judges are handling it.
Is there anything else that we sort of should be on the lookout for in terms of these climate cases? Or?
Those are the biggest things. One thing that we're both looking out for is next month the DC Circuit is going to be taking up a whole slate of new LNG cases. So we saw them, recently side with the Department of Energy on saying the Department of Energy didn't need to do this in-depth climate analysis. We have these new cases coming up in October for oral argument, so we'll see, kind of what questions the judges are asking and whether they seem to be moving in the direction of the case that they already decided, where they sided with DOE, or if they're moving in the direction of the pipeline case where they sided with the environmentalists against federal regulators.
Yeah. There's also some contention going on with regulatory rollbacks. That was something Trump has really been pushing, and in some sense the courts have sided with the federal agents on this, but other times they think they've been a little bit too creative. Can we sort of go over what's going on there a little bit, Ellen?
Yeah, so the 2 best examples of where the courts have kind of pump the brakes on the administration's attempts to roll back or freeze existing rules. In one case, the DC Circuit ruled that EPA had used this provision of the Clean Air Act to freeze standards for methane emissions from the oil and gas industry. And this particular provision that EPA used, the court said that wasn't really appropriate, so the court rejected EPA's move. So that case is still ongoing, and we'll see what happens with the standards. And in another case, a different court, a district court in California, decided that BLM had misused a provision of the Administrative Procedure Act to pause a rule that was related to how royalties are calculated for fossil fuel development. So that was interesting in itself, but what might be even more interesting is what happens now there's at least 1 or 2 other rules where federal agencies used that same APA provision to freeze a rule. So we'll see what happens with those cases.
Okay, yeah, that will be very interesting to keep watching. And in all of this, there's nominees that President Trump has picked for lots of different courts. And you've said you're up to your eyeballs in nominees. Can you take us through some of the more important ones and maybe some of the courts that we should be watching?
Sure. So I've been paying attention mostly to vacancies in federal appeals courts, which are the courts that have the final say on things before issues potentially get up to the Supreme Court. In all, so far, President Trump has appointed three appeals court judges and 2 district court judges. He's nominated some 4 dozen judges in total for vacant seats in appeals courts, district courts, and other federal courts around the country. So been keeping an eye on all those. Every couple of weeks, the Senate Judiciary Committee has been holding a hearing on another round of nominees. One of the more recent ones was earlier this month when, right after Labor Day, Trump announced his pick for the vacant seat in the D.C. Circuit, which obviously is very influential in environmental and energy issues. Judge Janice Rogers Brown retired recently, so Trump picked Gregory Katsas to serve in that vacant position. He's currently serving as a top counsel in the White House for Trump. He's a Jones Day attorney. He's a big name in sort of conservative legal circles, so it'll be interesting to see how that plays out once it gets to the Judiciary Committee and the full Senate.
So, getting through the committee and to the Senate and even getting a vote, are we going to see some movement on these nominees anytime soon, or is it sort of all just sort of stuck in Congress right now?
Well, it's kind of yes and no. There have been, Democrats and Republicans have, very different ideas on how the process is going. You've heard from Democrats that Republicans are trying to rush through these picks. Including today at a hearing in the Judiciary Committee, Democrats were on the panel were sort of accusing the majority of holding this hearing, even though they were opposed to it because the full Senate is out of session as of yesterday evening. Republicans, on the other hand, and outside conservative groups say that Democrats are stalling the nominees. There's been a lot of talk about the so-called blue slip process, which is a Senate Judiciary Committee tradition that allows a senator to block a judge nominee from his or her home state. So how it works is that they have these blue slips that they either return to the Judiciary Committee or they don't, and if they don't, the nominee doesn't go forward. So Senator Al Franken has used that one recently to block one of Trump's judge picks.
So it's literally a slip of blue paper.
So
That's crazy.
So there's sort of a lot of, Democrats say that they should be allowed to use that tradition should carry on because during the Obama administration, some Republican senators used that to block some of Obama's nominees. So there's a lot of back and forth about that right now.
Yeah. Great. Well, these are all certainly really interesting things to keep eyes on: the climate, regulatory rollbacks, what's happening with SCOTUS. And so we thank you so much for sharing your great knowledge with us, and we look forward to the stories you'll have for E&E News. You can read more at eenews.net, and thanks for joining us.